les déclarations d'utilité publique. Voilà les 3 niveaux.
Okay. Yes, both in France, Belgium, and most part of Europe operates within a general legal tradition called civil law. And civil law primarily is based on statutes and declaration, and a declaration that this is the law by the legislative body. And civil law predominantly sits on statutes as its primary source of law. The only other important tradition of law in Europe is in the United Kingdom, which instead of having a civil law, has what's called the common law. Have you heard of the common law before? Have anyone heard of the common law? Yes. Yeah. Now, the difference between the common law and the civil law is the common law does not totally depend on statutes and legislation. It also depends on precedents set by the courts of law. But civil law in Europe, even where you find differences, maybe parts of Scandinavia and even parts of Eastern Europe, where they had a socialistic law tradition, all of that are grounded in civil law, because the bulk of civil law originated from Roman law and canon law, that is church law. It's only the British who have a different system. But of course, Britain is an island. They can choose to opt out. Now, the common law in England, what it means is, England used to have a number of kingdoms. And the common law is, what was the law that was common to all of the kingdoms from time immemorial? We use that expression, from time immemorial. But in English law, time immemorial means 1189.
1189.
Yes. So what was the law that was common in all of the kingdoms of England in 1189? So that became the start of the common law. So you can see that that alone is not enough to govern a modern nation, even a medieval nation, and certainly not an industrial nation. So the common law had to be supplemented with statutes and different forms of law, not totally dissimilar from civil law. So where we are at now in terms of European law, especially when it relates to corporate law, there is a great degree of similarity and flexibility. So most of the things you see relating to corporate law in common law is also applicable within civil law. Now, it is very likely that all of the organizations you have and you are running would fall under one or more of these legal structure options. By the way, I should also mention that the almost homogeneity of civil law and that little bit of common law is replicated in Africa, because of course the former colonies in Africa have adopted both civil law and common law jurisdictions. There have been modifications in terms of company legislation. So it's very likely that your institution, your organization, is a form of company. Maybe a company limited by guarantee. It is perhaps unlikely that it's a company limited by shares, because a company limited by shares, usually that's the one that commercial companies use. If you are not a company, it is very likely that you may be a cooperative of some kind. Maybe an industrial society, a provident society, a mutual society, or a friendly society. If you are not one of those, it's very likely you are a charity of some kind, a not-for-profit association, or a non-governmental association, or a trust. can you think of, can anyone here has an organization that is illegal, that has a legal structure that is not one of these? So it looks as all of your legal structures you use for your organization falls within one of these, which makes sense. So what we will do is tease out a little bit what each one of these means. Both just a little bit about what is the law about it, but more importantly, what are the management issues and the governance issues. Now, before I go in starting from the companies, is there anyone here who's operating an organization that is not registered at all? You are. So you are very likely under that category of an unincorporated body, an unincorporated group. Yeah? And very soon you will be advised as to how dangerous that is.
But we are ready to...
Now, if we look at the company structure, company as a form of legal structure is the most successful the world has ever seen. If you think of the different types of legal structures, being cooperatives, being political parties, being trade unions, being companies, company as a legal structure is the most successful. There is a very long and distinguished history of companies, even going back to ancient Egypt. The concept of a registered organization that operates on its basis, distinct and separate from the people who produce it. Some would say that in Europe, the oldest company that was ever set up was a mining company in Sweden, set up in the 14th century. Now, by the time you come to the 18th century, then company law is being standardized and there's clear legislation, mainly propelled by exploration of sort of the world and of countries that later became the colonies. The important element about company law, and part of the reason why it is successful, there is applause somewhere. No, where is it coming from?
Well, the only Obama has been elected.
Maybe from someone's mobile phone.
Yes. That's Obama's one.
So let's see, yes. Now, what companies do, the first thing they do is they allow for incorporation. Incorporation, the word incorporation, its origins, its etymology is from the Latin corpus, meaning what? Meaning body. So incorporation means the creation of a new body. So when you set up a company or you incorporate in any other way, you have created a new body in the eyes of the law. So in fact, if you set up a company, all of your organizations, when you set it up, you would have received a certificate. That certificate is like a birth certificate. So in the eyes of the law, a new person is born. That is why sometimes you hear lawyers talking about natural persons. And you wonder, natural persons? Are there any unnatural persons? There are unnatural persons in the eye of the law, and those are companies and other corporate bodies. In the United Kingdom, you would see that there would be a bias in the common law, because of course I was trained in the common law. I can't be bothered with civil law. Yeah? Now, in the UK, the first major act was 1862. So it's written down almost as in the civil law tradition. There's a statute that sets it out. And soon after, within 30 years or so, there was a very important case called Salomon v. Salomon, which re-established and settled any doubt on the issue of separate legal entity. You see, if it is true that when you incorporate, you create a new legal person, so that means that that person is distinct and different from the people who created. Just as if a child is born, that child is distinct and different from the parents. So that is the concept that Solomon and Solomon established. But perhaps most importantly, in that case, one of the House of Lords judges, a famous judge called Lord Macnaghten, in his judgment, made a long, interesting statement, and I've just taken a short quote. By the way, in English law, Lord Macnaghten is better known for having set out the rules that explain that people who have mental illness cannot be found guilty of murder and other crimes. It was the Macnaghten who set those rules. But on this matter, he said, remember we're talking now about our new legal person, he said that the company, that is this new person, attains majority on its birth. There is no period of minority, no interval of incapacity. So unlike natural persons, there are times when we are minors, we are children, in which we are not responsible or capable in the eyes of the law, and we are not legally liable. Companies are not like that. The day they are born, they have capacity. There is, according to Lord Macnaghten, no interval or incapacity. There is no period of minority. So this gives us a hint as to why companies are a powerful struggle. It's a powerful structure because they create a new legal person distinct and separate from its owners. That allows people then to take risks with companies and to enter into ventures and exploration, because now my house is not necessarily at risk, because it's the business that's doing, the company that's doing the business rather than me. And that point is reinforced by